Now we'll discuss regarding the capacity to make a work. And regarding that, we'll discuss the Work Validating Act 1930 and Work Act 1954. They expressly provided that a work can be made only by a Muslim and he should 18 years of age and of sound mind. A work cannot be made by a guardian on behalf of the minor, and such a work is void. And according to Amir Ali, that classical jurist of Islam also provide a non-Muslim could make a work. Similar views were expressed by some leading cases such as Kashmir versus MSW Board in 1964. The Madras High Court expressed that also in another leading case, that is Hundaria versus Shyam Sundar in 1963, the Patna High Court, and in Moti Shah versus Abdul Ghaffar in 1953 by the Nagpur High Court, expressed that the various views expressed by Amir Ali was upheld by these decisions, but the Muslim jurist unanimously rejected these observations made in those leading cases. And at present, it is only Muslim who can form a trust or work as per the personal law of the Muslims. So now we will discuss regarding the subject matter of works and as provided under the Work Validating Act 1913 and the Work Act of 1954, which laid down that work may be made of any movable or immovable property. So all kinds of land, fields, gardens, working cattle, implements of husbandry, warehouses, swords, cash, copies of Quran for reading in mosque, a government promissory note, etc., can be validly made as subject matter of a work, but the essential requirements which were provided by the very provisions are it must be under the ownership of the person making it, and the Wakf must have permanent dominion over the subject matter of the work. So a work may be validly made of the property, the subject to mortgage or lease. A work of Musa is not valid according to Imam Muhammad. According to Abu Ishaq, it is valid. So also according to Abu Ishaq, a work of Musa, whether capable of division or not, could not be made for a mosque or a burial ground, but a work of Musa for maintenance of a mosque is only valid. So now we'll go to the very formalities of a work. So, regarding that, a work may be formed either in writing or in oral as under Islamic law. No specific word, even the word work, and no specific formula is provided. The essential elements of creation of a work is that the language of the dedication should be clear and unambiguous. Mere dedication or mere intention cannot create a valid work. And regarding that, we'll discuss the views of Abu Yusuf, Imam Muhammad, so also of the Shias and the Shafis, so also the views of both Sunnis and the Shia schools, and the very provisions of Section 17 of the Registration Act of 1908. So, as per the formalities, Abu Yusuf held the view that mere declaration is enough. But Imam Muhammad considered that the declaration must accompany the appointment of a mutawali and delivery a position to him. The Shias insist on delivery of position, but the Shafis holds delivery of position is not essential. But both Sunnis and the Shias agreed on the point that Wakif can himself be the first mutawali and no transfer of property is necessary, as the Wakif is the mutawali himself. And Section 17 of the Registration Act of 1908 provides that if the work property is immovable and valued rupees 100 or more, it shall have to be registered for the validity of the work. And regarding there are certain characteristic features of a work, and those are: a work is essentially based on a legal fiction, the fiction that the property vests in God in perpetuity, but income from the property to be utilized for certain specified purposes, which under the Muslim are recognized as pious, religious, or charitable. In the leading case, Muhammad Ismailia versus Thakur Sabit Ali in 1963, Supreme Court held that even in a work for halal or family work, the property is vested with God. The apex court rejected the contention that it is vested in the mutawali or the beneficiaries, and also it must be permanent in nature. It is created for an unlimited period for the purpose mentioned in Islam of a permanent character. So Abu Yusuf said that once property is dedicated by way of a work, the right of the Wakif or the founder automatically stand extinguished forever. There must irrevocable that particular work which is made. So, in regarding that, the Hidayah expressed that once constituted validly, a work cannot be revoked, but a testamentary work may be revoked by the settler at any time before his death, as it is a bequest. However, a Wakif has the right at the time of dedication to reserve to himself the power of altering the beneficiaries either by adding to their number or by excluding some of them. Also, the properties of work are inalienable as work properties are vested in God and permanent in nature, so they cannot be alienated. But if the Waknama allows the Mutawalli to alienate under certain circumstances, then he can alienate work properties also with prior permission of the court. He may sell or grant lease of the work properties. So these are the important characteristic features of a work as per the provisions of the Work Validating Act 1913 and the Work Act 1954, and as per the authoritative views of the mullahs or the qazis such as by Abu Yusuf or Abu Hanafi or Imam Muhammad. So also by the very decision of the Supreme Court in the leading case Muhammad Ismailia versus Thakur Sabif Ali in 1963,